Yes.
Apropos, my lord, yesterday's Lord, regarding my lord, that second constitution bench, my lord, yesterday, my lord indicated, lord, we have taken instructions. Lord, the position is this, my lord. In 2020, lord, other honorable judges, my lord, may not be aware. My lord, yesterday, the discussion regarding next constitution bench under the IDA, and I was to respond. What is the position? Lord, the position is in 2020, there is an industrial code which is passed by the parliament. But since rules are in the process of being made, it is not yet notified. But there the definition of industry is in conformity with Bengal water supply.
Oh,
Sorry, Bangalore water supply laws. So, the suggestion subject to the approval of the honorable benches, if it can go, after vacation, we can also take a call whether to amend the definition or what stand the government would like to take. That's otherwise, we are ready and we will.
We can then put it out. July then, because anyway we have now two days this week and 3 days next week.
Only 1 week, practically, 1 week. Because yesterday, tomorrow, your lordships have fixed some the judges matter also, and this can't be over in a week. The industrial dispute matter can't be over.
We can keep it in July on the reopening. We'll notify the date.
Yes. Lord, kindly come to volume 2D, capital D, Lord, D for Delhi. Lord, my submissions on Article 39. But before that, my lord, I would wish, my lord, your lordships to see Article 37, which is not, my lord, of course, your lordships would be knowing about it, but it's not brought to your lordships' notice in this matter, my lords. That would show, my lord, the sanctity which the framers of the Constitution have attached to directive principles of state policy. 37, my lords. But last lines, my lord, are, in my respectful submission, yes, my lord, even lawmaking. No, not, my lord, just executive governance, even in lawmaking. Application of the principles contained in this part. The provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles to making laws. There is a constitutional obligation, so to say, on the legislature also to apply these principles. Now, my lord, kindly come to, my lord, my note, volume 2D. My lord, the width of Article 39, because, my lord, your lordships, obviously, my lord, would bear in mind the question, my lord, which is being, for which we are assisting your lordship is whether a private property would fall within 39 or not, my lord. In that context, my lord, this is my perception of Article 39. The ownership and control of material resources of the community are so distributed as best to subserve the common good. My lord, each word in my respectful submission, my lord, is, my lord, pregnant with meaning of making a welfare state. Lord, if I have to, my Lord, give one word for this entire article, it is to create a welfare state, my Lord. Now I would dissect, my Lord, why each word is used very carefully by the framers of the Constitution. But it says ownership and control of the material resources. My Lord, if the framers of the Constitution would have envisaged that the property owned by the government to be used for the purposes, my Lord, which are mentioned, then there was no occasion for them to say that ownership and control would be used. Ownership and control would necessarily mean that something which do not belong to the government, but in the larger interest of the common good, there can be a law passed
But these have to be on resources of the community.
I'm coming to that. The word used is not material resources of either the state or the government. It says resources of the community, which again leads to an indication that it includes both government property and other than government property.
Learned Solskjaer, you must have, since we are on 39B.
My lords.
And you are proposing to dissect the words there. Now, obviously, you are also going to look at, now when you say ownership, not with the government, it is obviously in the private sector.
Both.
Right.
It can include both.
It can include both.
Both.
So ownership and control of material resources, as the Honorable Chief Justice has pointed out, and what is to subserve the common good.
I'm coming to that.
Right. This common good element is very important because
that's the, my lord, key word in the entire section.
That's right. So whether common good, of course, this is in the context of the provisions in the MADA Act. Whether
in general, we are, my lord.
Yeah, that's right. I mean, you are giving a broad interpretation.
Correct.
The discussion also has to relate to what is contained in the Maharashtra Act.
Yes.
Pertaining to the properties.
Yes, my lord, but nobody touched, my lord, MADA Act from the point of view of its validity, etc. It was just by way of an example. But I am, my lord, broadly, irrespective of, my lord, MADA or any movable or immovable property, any property. Property can be, my lord, a private mine, for example. It is a material resource. It is a resource not belonging to the government because it's a private mine. But therefore, my lord, the key words are, it should be, if any law is made under Article 39B, it should be A, for distribution. B, it should be to subserve common good, not good of any particular section of the society. Therefore, I say common good is the key word, my lord, of this. That you take over some property for the purpose of, say, one section belonging to one race, one religion, one caste, one profession. That is not what is contemplated. It has to be a community property not belonging to the government. It is required for being distributed, and the ultimate goal has to be common good. And therefore, my lord, in one word, this, my lord, provides for an ideal definition of a welfare state. This is not distributive justice.
The question is whether ownership of the community is also equivalent to ownership of an individual, or ownership of a community also encompasses individual ownership of property. That is the question.
My lord, that will have to be, my lord, so read. Otherwise, it
Whether a
gives-
community means an individual.
I would answer that question, my lord. It will have to be so read, depending upon the facts and circumstances. For example, my lord, in my house, there is a rare mineral which is discovered. It's not a property of the community, it's a property of the individual. But then the key word would be material resources. If individual property has material resources which can be distributed and ultimately for common good of the citizens.
Therefore, actually, your example is very apposite, because what your example shows is that there may be instances where, in respect of private property, there is a community interest. Now, this is clearly a case of that nature. Namely, though the property is of a private individual, underlying that property, you have say uranium, or you have some very rare,
Yes,
rare resource, which is really a resource of the community. And therefore, there can't be a very strict dichotomy between private and public. At the same time, it is a little too extreme. The formulation by Justice Krishna Iyer is a little too extreme. What that formulation says is, since the community consists of individuals, and therefore every individual is a part of the community, if the material resources of the community would therefore mean also resources of the individual.
No, my lord, it will
That may be a little extreme. I'll tell you also.
This would be an extreme, my lord.
It would be a little extreme. Also, we must now be cognizant of the fact that all these constitutional provisions are they have an evolution. We are now interpreting them not in the context of the India of 1950.
Nationalization to disinvestment. That's
Right.
the
Yes.
transition.
Therefore, we must adopt an interpretation which is in keeping with the changing nature of the times and the society which and at the same time, we must also have an enduring interpretation. So it may well be that certain resources which are vested in private individuals may still have some general bearing of public interest or community welfare, the welfare of the broader community, which requires regulation by the state.
Yes, but for example, land, road, making of a road. Lord, land is a material resource when you, when the function you are discharging is making of a road. Lord, some land is coming in between. Lord, it is for common good, for distribution, and it is a material resource, maybe belonging to not the entire community, but an individual. So, Lord, therefore, the law will be in tune with if each and every word is existing, my lord, simultaneously. And I would, my lord, add one more thing.
Also,
Ownership.
39B postulates that there has to be a diversification of ownership and control. Why does it say ownership and control of the material resources of the community is distributed? So this is speaking about the need for diversification of ownership and control to protect the common good. That is, you don't want a concentration of economic resources in the hands of...
If they are material resources.
They are material resources of the community.
No, it's not, my lord, for example, my lord, a rustic.
Dispersal would maybe or that's what distribution means.
Yes, my lord. Because, my lord, for example, a rustic way of looking at it is that you total up the wealth of the entire nation, divide it by the people whom you feel that needs to be distributed. And whatever is the figure, distribute it. My lord, that's not, my lord, what 39 means. My lord, that would be a lack of understanding of governance as well as economics.
We can't attribute to Article 39B and C, at least in today's times, a sort of a definition which gives, expression to an unbridled agenda of communism or socialism.
Absolutely.
But that is not our economy or our constitution today. We still protect private property. We still protect the right to carry on business.
Property.
We still want, as part of, say, a national agenda, I won't say the government's agenda, because this is across...
No, it is an agenda of the nation,
from
whichever is the government is.
From 1990.
Yes.
And so it was irrespective of party lines and government. We have now expressly adopted a policy of encouraging investment by the private sector, realizing that until then it was all right that the government was involved in very high levels of investment in the industry. But now, truly, if we have to have a productive enterprise, you have to encourage private investment.
Yes.
And therefore, our interpretation must also be, nuanced. to take care of what India is today and what India is moving towards tomorrow.
Lord, investment in the private sector is now boosting common good. Then, my lord, what was envisaged in, my lord, 49, 47?
For instance, in 1950, nobody envisaged that you would have electricity distribution by private companies on such
Private
a
companies.
scale. Now you have that today.
Yes.
They couldn't have envisaged that, well, the private sector will be building up infrastructure like roads, like ports.
Lord, one of the judgments, very illuminating judgment.
Airports.
Airport, my lord, for example, about airports, my lord, some of the activities are, my lord, privatized. Not the essential activities like customs, security, etc. But some of the activities are privatized.
We may not have a very strict dichotomy that, well, something which is totally privately owned can never be a material resource of the community. That will be a very extreme statement.
Yes.
But it would be an equally extreme statement to postulate that everything which is private is a material resource of the community, which the Attorney General argued. That may not be a
Your argument is actually going contrary to what the Attorney General
You are
was.
more-
I would, my lord,
more in the middle. You're
a little
taking
new
part.
nuance, my lord. I would not, my lord, argue contrary to him, but my nuance is different, my lord. Your lordship knows, my lord, what I am trying to say, my lord. And my lord, so far as, my lord, the view expressed by my lord Justice my lord, Krishna Iyer is concerned, my lord, it deserves respect. But with respect, my lord, I would personally and on behalf of the government, my lord, would not subscribe to that view at this stage of the
Exactly.
country's economic development.
We'll be sending a message across because what we write will send a message of what India is and what
Yes.
India aspires to be.
Yes.
So any interpretation which we don't want to dilute the constitutional or social significance of 39B and C. It's there for us. I mean, it's given to us. At the same time, we should not be sending a message by interpreting 39B in such a wide sense. There is no protection of private rights in the society
Yes.
at all. How will we attract private investment if we say that there's no protection afforded?
It's counterproductive. That interpretation may not be in national interest, my lord, but
But
we
we will
have
not go as far as to say that anything which is private can never be a material resource of the
No,
country.
that's not, that's another extreme.
Cannot be. Yes.
That's another extreme.
Yes.
For example, my lord, in Mada, my lord, if the government sees that there are, say, 500 people staying in 500 dwelling units, which are in a dilapidated condition, they may have their own justifications for staying, and there is a justification because roof over the head is a justification. The owner, who is the landlord, he will not spend because he has a justification that I am getting less money. The government is not concerned with their ownership dispute or tenancy dispute. The government would merely say that we are concerned with your life. We provide for a mechanism under which we will evict you. Somebody would pay you the rent for the interregnum till your houses are newly constructed. You fight it out whether you are a tenant, you are a deemed tenant, you have to be evicted, etc. That's not the contractual relationship we are concerned with. So that would be material resources of the community requires proper distribution for common good. So, my lord, therefore I say that each word is pregnant with meaning, and that is how, my lord, we will, your lordships may consider taking a path which is neither on this extreme nor on this extreme.
More balanced perspective
My
on.
lord, that's the.
See, for
respect.
example, an individual owner, in this case, an owner of a building which is in a dilapidated condition,
So that we will answer it separately. We will answer it separately.
and this, it all depends to what extent.
My lord, that, my lord, MADA Act and the validity of individual acts, my lord, there are separate answers. There are separate answers to that. But the government would not enter into that area of tenancy owner, my lord, owner-tenant relationship.
Right to develop.
That's not, my lord, the issue. Please, for the time being, Lord, that we have, my lord, our justifications for the purpose of protecting the validity. That was just taken up as an example. Therefore, Lord, I am not going much into it. I am more on a wider canvas for the nation, for the national economy, and the economic growth at which the nation is progressing at this stage. What should be the meaning of
So
this?
how would you formulate it? So we can just take it down, it will just give some clarity to us. We
Yes,
can
my
just
lord,
take a
my
more
formulation is
process,
this,
You
my
can
lord.
reflect on it and tell us,
Lord,
how would you formulate
Yes,
it? We can
Lord.
just take it.
the 39 small b is a measure for developing
A little slower.
a welfare state with the ultimate goal of common good. I'm sorry, madam.
Goal of protecting the common good, we'll say,
Common good, the ultimate goal of protecting the common good
or achieving the common.
or
good.
achieving, my lord, I'm sorry, madam. When material resources of the community needs legislative intervention of either taking over ownership, and this is my nuance, my lord, and oblique or control. The constitution says and, but I'm saying it can be read even as or. Lord, sometimes, my lord, why I say or? Lord, suppose there is a private mine. The government may not take over the
How would you
ownership.
but you have to complete the sentence.
I'm sorry.
When material resources of the community need legislative intervention or taking over ownership or control,
To achieve, my lord, that common good of the
I'll tell you how you began.
control of the material resources. I'm
Article
sorry.
39B is a measure for developing a welfare state with the ultimate goal of achieving the common good. Then is it comma, when material resources of the community need legislative intervention of taking over ownership or control?
Of ownership or and oblique or
And or
control
control.
For taking.
of material resources
Need
Of-
legislative intervention of taking over ownership or control
and oblique or, my lord, and or, because constitution says and or is, my lord, my
Taking.
interpretation of material resources of the community
For distribution.
for distribution.
yes,
Just going back to this, can we, I mean, we're not putting you into a corner. I mean, it's a thinking aloud. Can we say that you don't accept either of the two extreme positions? I mean, as a government, one extreme position is that every element of private property is a material resources of the community. That's one. Just think over it. Second, that no private property can be a material resource of the community. There are two extreme
my
positions,
lord, I
One-
think I, my lord, respectfully agree.
isn't it? Because
I
there are
respect.
two extreme positions that no private property can be a material resource of the
That
community.
is one extreme.
And second, that every private property is a material resource
No,
of the
no.
community. So we
Taste-
eschew both the.
The
Can
taste
we
that-
take it down? Can we take it down? Because
Yes,
just
sir.
it'll give us some clarity later on.
Yes, my lord, the taste, if challenged, my lord,
You'll have to formulate it,
yes,
because then it will depend upon the context.
Exactly.
See, this is, this is everything.
my lord,
This will be maybe the crux of the matter, because then everything perhaps may depend upon the context, upon the situation. As the chief rightly said, the interpretation of the 50s and 60s may not be relevant now.
What?
Constitution, therefore we say it is a
Context.
living document,
It has to be seen
changes its meaning.
in that way. You have to tell us, and you'll have to also tell us what do you understand, how should we understand community?
Yes.
So that
My lord, may
also
I do one thing, my lord, instead of, my lord, your lordships, my lord, being troubled with writing down, but I'll prepare one paragraph and give it to, that this is how my stand is, but I, my lord, agree with so far whatever, my lord, the Chief Justice has said, and my lord Justice Dhulia has said, that it depends upon the context. Depends upon, my lord, what is community. Contextually, it can even be an individual, if the material resources are community based.
No, I'll give you an example. For example, let us say there is a community, a tribal community, right? They know where a particular herb or something is to be located. Well, now, that belongs not to an individual, maybe lying in an individual farm or agriculture field, but it will belong to the entire community, right?
Correct?
But the community, will it be the only that tribal community or people of that area or the entire country? That you will have to tell us, because when 39B was being debated, one of the bill was to make it community of, instead of, it should be citizens instead of.
My lord, K.T. Shah, my lord, Mr.
Something,
K.T.
so it was not done. So deliberately this word community was chosen.
To make it wider.
But how wider? When wider and when narrower?
Instead of, my lord, my responding immediately, my lord, can I at the end of it give, my lord, my version of it? But so far I am, my lord, completely, Lord, bow down and in agreement with what my lord the Chief Justice has formulated.
I was just, as you were having this conversation, I was listening to Brother Dulia and you, and I made a note on the context. Now, in the context, we can identify three factors at least. I mean, this I've just done it offhand. One, what is the nature of the resource and its characteristics? Airwaves. Very different from a private property of a different nature. So what is the nature, the spectrum? The nature of the resource and its characteristics. Two, the impact of the resource on the general well-being of the community or the common good. Third, the consequence of the concentration of ownership and control on the common good.
So that may perhaps not be.
Some resources you may not want them to be.
Yes, like uranium. I understand.
Right.
I bow down. That it cannot be with one individual.
Scarcity of the resource.
Yes. Your lordships, if that my lord is added, my lord, then scarcity or any peculiar significance of that resource is not left.
These are by no means exhaustive factors. They
Yes.
again have to be evaluated from case to case, from context to context.
Yes, and the class should be identifiable class. The community doesn't mean the entire country. That whatever is there, you take it and distribute it. That's not, my lord, a juvenile way in which the constitutional framers have, my lord, understood.
So the thrust of 38 and 39 is that wealth of the nation or the material resources, as they say, should not be concentrated in a few hands.
If it is
That's the-
required for for common good, and not that it should not be, the government is enabled through parliamentary legislation to intervene and, my lord, take either ownership or control. So there is no prohibition that it cannot be. But if other conditions are fulfilled, then the legislature can intervene.
The word is shall, not 39, 38. The state shall strive to do so.
Yes, while making the law. Yes, my lord. Therefore, I am saying, your lordships are right, that enabling provision is to make the law where this will have to be borne in mind. My lord, I'll give one
Yes.
paragraph, my lord.
So now what next you want to
Now,
formulate?
next, my lord, I'm skipping what is not relevant. My lord, I have given the definitions of control, ownership, etc. But just only one line. My lord, the constitution says ownership and control. But I would respectfully urge that the words are disjunctive. It can be or also. For example, my lord, why I say so? My lord?
To read ownership and control as ownership or control.
And or both. I'll give the example. For example, in a private mine, there is a huge tract of land, my lord, belonging to me. And there is some, my lord, a mineral discovered there. The government may not be interested in taking over the ownership of the land. Ownership may retain with me. They will take control over the land. So how much mineral will be excavated? What will be the royalty to be paid? That's
And ownership actually.
Therefore, my lord, I'm saying that depending upon the context, it can be ownership and control. It can also be ownership or control, depending upon, my lord, the context. Your lordships can skip the definitions if they are, my lord, quoted only for the purpose of,
So solicitor, where are you on the note? Which page?
my lord, up to page 8, my lord, there are definitions quoted. This is only for ready reference. I'm not going to read it. Please come to page 9, my lord. My lord, drafting history.
That 9-page note, no?
No, my lord,
No,
I'm sorry.
16-page note.
My lord, volume 2D.
2D.
2D, my lord,
I thought
I'm
2B.
sorry, my
I
lord,
thought you said 2B. All right.
Well, I said D for Delhi at the beginning.
Yes.
my lord.
I took it as D. Yes.
Yes. Lord, kindly directly come to page 9. my lord. PDF 11.
So 2B was solicitor's 16-page note. I said solicitor has been uncharacteristic in this case. Now I realize it's 74 pages.
My lord, why I am little longer? Well, there are two reasons. A, I quote the relevant para so that
You
your
have to
lordship
keep
may
on
not have
going there and
to
there.
shuffle through, my lord, various volumes. And second, my lord, the reason Winston Churchill gave, that I'm writing you a long letter because I don't have time to write a short letter. So because you really need precise understanding of the subject to write something crisp.
Churchill or Shaw?
Pardon?
Bernard Shaw.
Bernard Shaw, actually. It was George Bernard Shaw.
Yes, my lord.
Isn't it? That's from my recollection. I mean, I may be wrong.
My lord, my lord, there are three individuals. Lord, there are three individuals.
Brother
To whom-
Dulia has made a comment. I
Takes
think
more
that's
effort to
relevant.
be short.
Yeah.
My lord, if it is not a privilege,
No, no, since you are such a
Writing is difficult.
Urdu adab and Urdu literature, somebody said that since I had to write a very small letter had to be written.
हिंदी में बोलिए.
एक छोटा सा खत लिखना था, इसलिए ज्यादा टाइम लगे. छोटा सा लिखना था.
yes. And तो नहीं ना, मुख्तसर सी बात है.
हाँ, मुख्तसर हो जाइए.
Yes, there is a गजल, मुख्तसर सी बात है, तुमसे प्यार है. But that's the short thing I want to say. I don't need an essay for that. Mukhtasar means, my lord, short.
It takes more effort to be precise.
That's exactly what, my lord, Churchill or Bernard Shaw or whoever. My lord, these are the three individuals to whom most of the things are attributed. Churchill, Bernard Shaw, and Oscar Wilde. And Mark Twain. Yes, my lord, he is my lord, Mark Twain. And the same thing happens with Mirza Ghalib. Unfortunately, my lord, completely footpath level shairi is attributed to him. Last में वो मरीज लिख देते हैं, गालिब लिख देते हैं. Lord, para 9. Lord, what was in the mind of the framers of the Constitution? Well, I'll not read the entire, but Lord, please see the first. Lord, this is the discussion by one Mr. S. Nagappa. Sir, this clause is the only clause where the poor man, the common man, can find some hope for the future. Clause 2 and 3 are identified for the benefit of poor men. No doubt it would have been better if this clause had been drafted in more unequivocal terms instead of in this ambiguous language. As a layman, as a common man, I can see more ray of hope for the future in these clauses. It is the aim of the honorable members who have assembled here to socialize as early as possible. As long as these clauses stand, there is no possibility of capitalism thriving in India. I am very much thankful to the drafting committee and to the president of it, in particular for having brought in these clauses. And my only grievance is that they have not been drafted in more unequivocal language. Sir, so this is important, my lord. This is now changed. Sir, the slogans today are municipalize utilities and nationalize industries and means of production. And unless and until these things are done, there is no hope for the common man. My lord, now the economical infrastructure and the concepts, my lord, have changed from municipalization, that is nationalization, to, my lord, free trade, etc. Privatization.
Investment.
And that's what Dr. Ambedkar very prophetically said, that it is purposefully not made unequivocal because there can be different ways of dealing with an economic scenario. Then at the foot of that page, para 10, further, Mr. K.T. Shah had proposed the following clauses to substitute Article 39B and C. In that the ownership, control and management of natural resources of the country in the shape of mines, mineral wealth, forests, rivers, flowing waters, as well as in the shape of seas along the coast of the country shall be vested in and belong to the country collectively and shall be exploited and developed on behalf of the community by the state as represented by the central or provincial governments. Number 2 is relevant, that there shall be no private monopolies in any form of production of material wealth, social service or public utilities, nor shall there be any concentration of means of production and distribution in private hands, and states shall adopt every means to prevent such concentration or accumulation. This was the theory or the thought in those days, my lord. Now, please see, my lord, Dr. Ambedkar's reply, my lord, on 15th November 48. The second reason, my lord, this is Dr. Ambedkar, I quote, the second reason is that the amendment is purely superfluous. My honorable friend, Professor Shah, does not seem to have taken into account the fact that apart from the fundamental rights which we have embodied in the Constitution, we have also introduced other sections which deal with directive principles of state policy. If my honorable friend were to read the articles contained in part 4, he will find that both the legislature as well as the executive have been placed by this Constitution under certain definitive obligations as to form of their policy. Now to read only Article 31, that is draft article now 39. Your lordships can on the side mark that, which deals with this matter. It says, then they've quoted the article, draft article, which is substantially on the same line. Then I again read Dr. Ambedkar.
Yes.
Lord, your lordships can now come to, my lord, page 13, the highlighted part. Lord, the question is, it starts with, my lord, Dr. Ambedkar. My lord, rest may not assist your lordships on the question being considered. Therefore, I am skipping, but I have put it there, my lord, for completion. The question is, have we got any fixed idea as to how we should bring about economic democracy? There are various ways in which people believe that economic democracy can be brought about. There are those who believe in individualism as the best form of economic democracy. There are those who believe in having a socialistic state as the best form of economic democracy. There are those who believe in communistic idea as the most perfect form of economic democracy. Now, having regard to the fact that there are various ways by which economic democracy may be brought about, we have deliberately introduced in the language that we have used in the directive principle something which is not fixed or rigid, leaving it, my lord, for the next generations, as world economy develops, as Indian economic growth develops, to take a call which economic model the country would choose. Well, this is very foresight and my lord, almost prophetic, which is not fixed or rigid. We have left enough room for the people of different ways of thinking with regard to the reaching of the ideal of economic democracy to strive in their own way to persuade the electorate that it is the best way of reaching economic democracy, the fullest opportunity to act in the way in which they want to act. Sir, that is the reason why the language of articles in part 4 is left in the manner in which the drafting committee thought it best to leave. It is no use giving a fixed, rigid form to something which is not rigid, which is fundamentally changing and must, having regard to the circumstances and the times, keep on changing. It is therefore no use saying that the directive principles have no value. In my judgment, the directive principles have a great value, for they lay down that our ideal is economic democracy. Then highlighted part. To lay down that our ideal is economic democracy and also to prescribe that every government, whatever it is in power, shall strive to bring about economic democracy. Much of the misunderstanding under which most members are laboring will disappear. Then, my lord, Shibban Lal Saxena. This is a clause, my lord, he again deals with draft clause 31, the present 39. This is a clause which is very fundamental in our constitution. The character of the amendment suggested also shows that it goes to the very root of the whole constitution. My sympathies are undoubtedly with the amendments of Professor Shah, who has moved 2 amendments, which really suggest that in his clause, we should lay down that the system of our state shall be socialist. In an amendment to the preamble, I have suggested that the word socialist should be added before the word union. I personally feel that particular amendments which he has moved are very important, and I would urge my friend Dr. Ambedkar at least to incorporate the spirit of those amendments somewhere in the Constitution. Part 2 of Article 31 says ownership and control of the material resources are the same thing. Then Malodi further adds, this is maybe important, assist your lordships. Now this enunciation, ownership and control of material resources of the community to be distributed so as to subserve the common good is a very wide enunciation of a most important principle. The enunciation is so general that any system of economy can be based upon it. Upon it can be based a system of socialist economy, where all resources of the country belong to the state and are to be used for the well-being of the community as a whole. But a majority in the next parliament can also come forward and say that the New Deal evolved by Roosevelt is the best system and it should be adopted. This clause leaves it open to any future parliament to evolve the best plan of their choice.
So what was good for the country in the 50s up to 1991 may not be good after 1991.
Exactly, they wanted
So
to keep it open.
Evolving concept, and the clock comes back. We don't know when, after some time, privatization becomes so stressful that we go back to what was good in the 1950s in the decades to come. We don't know.
Therefore, it is left to Parliament.
It's all evolving.
Yes. And this New Deal by Roosevelt, is that capitalist
Is in soon after independence, they said the new dams, Hirakud Dam, Bakra Nangal, they are the new temples of India.
Yes, Bakra Nangal was the first.
Because that is what was necessary.
Yes, absolutely.
But now, after all that development, now the focus is on individual or private development. Country has developed to some extent. Now the private development or the individual development, therefore liberalization, privatization, globalization, investment.
Keeping pace with the international economic development, etc.
LPG.
Subject to correction, out of interest, this New Deal by Roosevelt.
This is the Second World War.
The Second
After
World War.
29 to 33, not the Second World War, sorry. 29 to 33 when there was a great, the Great Depression.
And those 4 horsemen and 3 musketeers, that's how the Supreme Court used to be consisting of 7 honorable judges and 4 judges always in majority did not permit Roosevelt to carry out any of these.
Because you know what happened was all the social welfare legislation like minimum wages, maximum hours of work, they were struck down by the Supreme Court of the UK or the US on the ground that they interfered with the private freedom of contract, or therefore the due process clause.
Yes.
And the due process clause was applied in a substantive sense, so as to allow the court to oversee what policy Parliament was, the legislature, Congress was following, the houses of Parliament were following. And the Justice Holmes was the dissenter.
Yes.
That the Constitution does not permit the court to adopt a policy which a majority of the judges think is proper. Eventually, the New Deal legislation was upheld by one judge of the Supreme Court. There was a court packing agenda. They
Yes.
thought that they will alter the
That was the word used, court
Backing
packing.
of the court.
by introducing a few more judges there.
10 more judges.
But then what happened ultimately was one judge switched his vote. And that vote which was switched is called in history the switch in time that saved the 9.
Saves the 9. And there are some interesting material on that.
And then they started upholding, all the social welfare
It was
legislation.
3 versus 3. One judge was not clear, and it is written somewhere. They used to travel. They used to ensure that they travel in the same car and constantly being persuaded, and he remained with the 4. Anyway, I'll just go further. Now please see the last word of Dr. Ambedkar at page in the script. The last concluding remarks of Dr. Ambedkar at page 50. It starts at page 14, but highlighted part at page 15. I think the language that has been used in the draft, a much more extensive language, which also includes the particular propositions which have been moved by Professor Shah, and I therefore do not see the necessity for substituting these limited particular clauses for the clauses which have been drafted in general language deliberately for a set of purpose. My lord, and the purpose is, this is, my lord, the emphasis I would very respectfully give. The object and purpose was that it is open for each legislature, depending upon the period of time they are making the economic policies, can have freedom to lay down economic legislations. Lord, complete freedom in joints is given to the Parliament. That's the intention.
Yeah.
So, my lord, ultimately, it is left to the Parliament. Therefore, a little not vague, but elastic, I would, my lord, put it that way, which can take into consideration the circumstances, factors, global factors, local factors, etc. Now, my lord, I am on page 16. Your lordships need not turn to. What I've said is this. The question, my lords, are deciding is whether a private property can include can be included under Article 39. What I have said is that when 39 was there, right to property was a fundamental right under Article 31.
Yes.
19(1)(f), my lord, I'm sorry.
Which page is this in your paper? Page?
16. 16. PDF 16.
Yes.
So, my lord, 39B and Article 19(1)(f), that is right to hold and dispose of property, coexisted, meaning thereby 39 always intended even private property. And its deletion now as a fundamental right and it going at as Article 300A further strengthens not that submission that 39B encompasses not just government property. Otherwise, for constitution makers, there was no reason to say that all property owned and controlled by the government shall be used for general good. Simple. Now, I have given the statement of objection reasons of 45th Constitution Amendment. I'll skip that, my lords. That may not be relevant, my lord. While going through, my lord, for writing judgment, if your lordship needs, my lord, I have kept everything, my lord, so that your lordships have on one click, my lord, get it. Lord, now please come to, my lord, page 25. My lord, I have given, again, my lord, for your lordship's assistance. I'm not going to read them, but if your lordships would wish to go through it or, my lord, record it, my lord, in para 24 at page 25, there is one annexure A, where, my lord, I have analyzed the provisions of other constitutions on this aspect. And that is at annexure A, my lord. There is no point reading them. Lord, your lordships can mark its PDF page 72.
Taken from.
Please come to page 30. 30. Lord, para 39, my lord, if your lordships can. So this is what, my lord, I have already, my lord, paraphrased my submission, but this is another paraphrasing. India is a social democracy that aligns closely with the principles of a social welfare state. Social and economic justice is not to be understood in crude terms of distributive justice aimed at a wholesale allocation of the material resources of the community to the people at large in one go. On the contrary, a welfare state means a rationally tailored policy intervention, that is legislative intervention, in furtherance of common good, which may or may not involve compulsory acquisition, ownership and or control of private property. The effectuation of the same is to be carried out in a manner conducive to the common good, thereby achieving socio-economic justice. My lord, I have cited D.S. Nakara, but my lord, your lordships may consider, my lord, for the time being, my lord, not, my lord, read that. Please come to, my lord, page 35. My lord, your lordships are aware, my lord, like which, my lord, we assisted your lordships on the ground of another article where you have to give a declaration that this act is enacted in pursuance to so and so. The same is with 39. The act stipulates, my lord, that we are exercising, the parliament is exercising powers under 39B B or C as the case may be. My lord, I have just, my lord, given a table of several legislations where the parliament has used and mentioned 39B. And my lord, please see the fourth column, material resource, my lord, which is sought to be regulated or distributed, my lord, under 39B. I'm not reading it. I'll just read, my lord, what are the material resources for which. Lord, Lord, I must add one thing. Lord, this declaration, the way in which, my lord, your lordships have seen, my lord, in other cases, my lord, of alcohol, industries, etc., is not mandatory in case of Article 39B. But even if an enactment is not mentioning 39B, the government can defend it on the ground that I seek protection of 39B and therefore 31. Yes, my lord,
It doesn't say industry, the control of which is declared by
is
Parliament.
declared by because the constitution requires a declaration. Here the constitution doesn't require the declaration. Lord, liquefied petroleum gas, crude oil, railway wagons and other goods essential to the need of railways. Then, my lord, 5 components of rolling stock like vacuum brake equipments, ejectors, steam brake valves, etc., etc. Some pharmaceuticals and chemicals, tractors, coke oven plants. Lord, some of them are repealed, some of them are in force, but that's not relevant. I'm just giving an illustration that these are the material resources for which the parliament did, my lord, take into account and mention 39B. Anglo-French Textile Limited, employing a large labor force. My lord, only one company was taken over, which is still, my lord, in force. That is Anglo-French Textile Limited, acquisition and transfer of textile undertaking. Then handloom and weaving factory.
But where you write the material resources Anglo-French textiles. I wonder what is that Anglo-French textiles. Anyway, that's.
It's a limited company, my lord, but
I thought I can say something here.
land, right to use water, Mysore Palace.
For example, a simple thing is the public distribution, where the farmers have to give levy sugar. The farmers have to part with some paddy to the state so that is taken.
Distributed equally.
Public distribution under
Public
the
distribution, PDS.
essential.
Yes, sir.
See, that is an example, clear, stark example, so close to the people.
I think the
Rationing of food grains.
learned attorney possibly, my lord, wants to say something. If
No, I was only trying to say about the Anglo-French textiles.
What's that?
I appeared in that matter way back in 1984. And that was a textile mill which is lying closed in Pondicherry for about 3 years. After the Honorable Court intervened, then the government set up a Pondicherry Textile Corporation. That's how it was taken over. And it was a private industry.
Oh. All right. Yes, Mr. Valentine.
Lord,
What
then
next?
please come to my lord. I have given 23 examples.
Yes.
This may not be exhaustive. We have tried our best to be, my lord, as exhaustive as possible. There may be my lord, legislations left, but public transport system, etc., etc. Lord, now kindly come to my lord, PDF 38, para 47. Where, my lord, this honorable bench, my lord, permitted placing of reliance under 39B while defending a particular challenge to an enactment. That is Bhim Singh ji, my lord, her ladyship, my lord, mentioned.
Case where there is a change in the mindset. 1976 Urban Land Ceiling Act came, and in 1999 it was repealed. That is during the times of 1999 post-liberalization.
Correct.
So 1976 and 1999, that is a stark example of how there is a evolving economic democracy
Yes.
in the country.
Depending upon several internal and external factors. And when I say external means global market, internal factor means, my lord, the production decreasing or increasing, the demand being less or more, etc., etc.
All right.
Lord, I'll just read the highlighted part of Bhim Singh Ji, where urban land selling laws were under challenge. The whole story, my lord, just above, my lord, just before the highlighted part, the whole story of the legislation, the long gestation of pre-legislative consideration, the brooding presence of Article 39B and C, and the emphasis in Section 23(4) on common good as the guiding factor for distribution point to public purpose, national development and social justice as the cornerstone of the policy of distribution, it is not and never can be compulsory taking from some private owners to favor by transfer other private owners. My lord, thereafter, my lord, this is all, my lord, last line, last passage, my lord, at page 39. I have already indicated that the postulate underlying the directive principles of Article 39B is that diffusion of ownership and control of material resources of the community is always in public interest, and therefore the state is directed to ensure such distribution equitable thereof as best to subserve the common good, but the priorities prescribed in subsection 1 and 4 of section 23 in regard to distribution of material resources produce contrary results as or results in the opposite direction, inasmuch as private purposes receive precedence over common good. My lord, that is more on the act, my lord. Then, my lord, there is one, my lord, this judgment is, my lord, very Tinsukia electricity, where electricity under 39B was taken under the control of the government. Justice. Lord, there are other judgments where 39B is considered, my lord, for the purpose of testing the validity of a particular legislation, my lord. Now your lordships can consider, my lord, directly coming to 48. My lord, I have given all those judgments where 39B is considered, my lord, but broadly, the view, my lord, which your lordships have taken is this, my lord, that ultimately it must evolve. It has to be left to the parliament, because the parliament is the best judge to decide under present circumstances how the economic growth will take place, whether a particular mode or a particular format is a better suited format or not. But page 48, Lord, Coal India, Lord, it is judgment, my lord, by 3 honorable judges, my lord, authored by Justice K.M. Joseph, a very recent judgment, of which, my lord, her ladyship Justice Nagaratna was also, my lord, a part of the bench, where Coal Mines Nationalization Act was considered. Lord, the issue was whether this act would, the Competition Act would apply to Coal India or not in view of Coal India, Coal Mines Nationalization Act. Well, please see, my lord, the underlined portion. Well, this is per Justice Joseph.
Which para you are reading?
Lord, para 97, page 48.
Para 57.
Para 57 of my note.
97 of the judgment.
97 of the judgment.
Para 57 of your note.
Yes, my lord. Recently, my lord, it starts with that. Recently, the lordship gets, my lord, Justice Roy gets.
Yes, yes.
Recently, a 3-judge bench in Coal India Limited versus CCI, that is Competition Commission of India, in the context of applicability of Competition Act, to Coal India, which was created under the Coal Mines Nationalization Act, it was held as under. The appellants are government companies. They were brought into being in the context of Section 3 and 5 of Nationalization Act. Undoubtedly, they were created to take the place of central government in the matter of supervising, control, and managing the affairs of the mines. Still further, and more importantly, the Nationalization Act itself was intended to achieve the goals in Article 39B of the Constitution. This means that the Nationalization Act contemplated coal to be a material resource and it was to be distributed so as to subserve common good. The exclusive right in regard to the mines, as also the power to manage and supervise the mines, was vested with the first appellant company and its subsidiaries. The ambit of the power is unquestionably wide. We proceed on the basis that the appellants cannot be oblivious to its duty to bear in mind the sublime goal in directive principles, that is distribution so as to subserve the common good. Lord, please come to, my Lord, next, my Lord, page 49, para 100 of the judgment. Does your Lord, am I with your Lordship? The expression common good in Article 39B is a Benthamite sense, involves achieving the highest good of the maximum number of people. The meaning of the words common good may depend upon the times, the felt necessities, the direction that the nation wishes to take in future, the socio-economic condition of the different classes, the legal and fundamental rights, and also the directive principles themselves. As far as the time dictated content of common good goes, it simply means that economics itself not being bound in chains, but it is a dynamic concept. This, my Lord, evaluation